Hello, hello. Good afternoon, good evening for some, good morning to some of us. We are still in the morning. Today, I wanted to come here. I didn't post any like event for you to join, but it's because I've just had some good news or some immigration new updates on any immigration law processes and rules that I wanted to come here and share. I didn't want to wait another week. I didn't prepare much, but regardless, I wanted to come here and share with you. So I'm going to talk about news about Title 42. I've come here on Facebook and on other platforms complaining about the Title 42. I have in the, I'm hearing myself. Let me see if I can read this. And I, and I also, I'm going to talk about Title 42 is being lifted, and I'm going to talk about a prospect of the Employment Authorization Document, EAD, processes being streamlined and also eligible for a premium processing. That's good news. And I'm also going to talk about the new rule about asylum claims. So I'm not going to take much of your time. Number one, the Biden administration has, announced that it's going to lift the Title 42. So for those who don't remember or who don't know what Title 42 was, it's basically title of one of the U.S. Code, Code of Laws, Title 42, which allows the Department or the Secretary of Health to to take a public health measure of refusing entry to individuals coming to the United States because of health safety, like safety of the United States, like safety of the United States, citizens and nationals is greater than allowing people, even if those were coming to seek asylum. So, and that has really, caused some type of discussions, outrage, because it seemed to be, I guess, discriminatory, against Black and brown migrants, specifically most likely from Haiti, and they were being refused. They were being expelled. They were not given a chance to apply for a asylum, and they were being refused, especially if you did come as a family or if you came as a male or single without children. So they were being expelled, no chance at all to even ask for asylum, and they were being expelled. So this Title 42 had been going on since the Trump administration. And when Biden came in office, he continued this program, which really has been, it's, you have to check my other videos where I did report on how many people from Haiti and other people from like brown, black skin, black migrants have been expelled without a chance of being afforded the due process of applying for asylum. So it is reported that this program is going to be lifted. I have an article right here. By the way, since the program has been established, a number of 1.7 million people were expelled under the Title 42 in just the past 2 years. So mostly under the Biden's administration. So yeah, and who knows how many before the Biden administration, right? So so what's gonna happen? I believe the Department of Homeland Security gave a date in May. I believe it was May 18. That so there is going to be lifted. So and the reason why I'm not too excited is because, oh, maybe I should be excited is because they're giving this administration is giving its time to end this program or this rule, this whatever you call it, until May 18th, if I'm not mistaken. But that's what I heard in the news. By the way, these are news. They just like CDC just announced today. It was yeah, it hasn't been happened, but I think I heard in the news that the CDC is gonna give an up until May or early May or in the mid May, to end this program. So that will give time to Department of Homeland Security now to set up the like what's gonna happen, because it is reported like people are waiting in line to just come in the United States after this Title 42 has been lifted. So the good news is, you know what, uh, the issue of migration, what they call economic migration, it's an issue, right? So that's a separate issue. But as an immigration attorney, as a practitioner, what I'm worried about is like, okay, you want to take measures to avoid people, that people misuse or uh, can misuse asylum laws for other purposes like economic hardships and all that. Okay, that's on you. But while the government is figuring out how to do that, they should not impede or the fundamental rights of individuals to seek, who actually really may be harmed. Or right now, because over millions of people have been expelled, some of them or most of them, we don't know, may have gone back and may have been harmed, including children, women, and yeah, or other people have been may have been sent back into the lion's den, who they are abusers, or they may. So while the government is trying to protect or to secure the border, like the government uses to put it, they also have to make sure they do not impede on other rights, such as due process rights to seek asylum, because the US is a signatory of the UN Convention for Refugees. The US has a codified the asylum law. So that's why this Title 42 had no business of being. It has to go. And then the Department of Homeland Security, with its stakeholders, they can figure out how to solve the problems of making sure they process people who are coming in, but they give a chance to everyone to provide their claim, and they sort through, like they have been doing, sorting through, and to see who qualifies for asylum without refusing, expelling individuals without even hearing them, because of this Title 42. That's why I am glad it is no longer a case. So let's move on, and thank you for you guys for coming, and as you come, you will follow. I don't want to be so, I guess, redundant, and let me move on to the new updates I wanted to share, and I will share in the last about the employment authorization, how to expedite, and what's new, the processing times, the premium processing time availability for the employment authorization, and which categories will be eligible for, it's called but like extending validity period for some of the categories. So stay tuned, but let me go through other news first. Okay. So the other news that's good news is the USCIS, which is the US Immigration Services and US Citizenship Immigration Services, has expanded the flexibility of responding to the agency request. That means if you have a request for evidence, you have a notice of intent to deny, a notice of intent to revoke, or you have a motion to reopen, to file or an appeal with the BIA or AAO, which is appeals administrative offices, then you have a flexibility of an additional 60 days, I believe, to the deadline. So if you received an RFE, annoyed IR, between March 1st, 2020 and July 25, 2022, you are able to the time to respond is expanded more. So if you get an RFE, request for evidence, that gives you 30 days to respond, you get to use an extra 60 days, flexibility because of the COVID. That has been adopted since the COVID, so it has been expanded. This flexibility is being expanded or extended until July 25, 2022. So that's good news. Something else I want to talk about is here. So the Department of Homeland Security and the Department of Justice, they were issued a new rule to process asylum claims. So this new rule will pertain to individuals mostly who come through the border who are subject to expedited removal. So most those people who are coming through the southern border, for example, and once they arrive or they cross the border, and once they are caught, they say, okay, we are seeking asylum. They are usually subject to expedited removal. And usually once they pass what they call a credible fear interview, they are being sent to be in line to be heard by an immigration judge. So to kind of streamline the process and avoid the backlogs, because immigration courts are backlogged. Now USCIS, which is the Department of Homeland Security, and Immigration Court, which is part of the Department of Justice, EOIR, which is the Executive Office of Immigration Review, they are working together to come up with a process where, so once somebody crosses the border and they are subject to expedited removal, this does not concern people who are inside the US who have been here for longer than 14 days or in the air. So the key word is, or the technical word, expedited removal. Those who are subject to expedited removal, and most of the time, those are the people who have come through the border and they are caught and they are put into removal proceedings, or they pass a credible fear interview. So since then, the credible fear interview is processed by a USCIS officers, like asylum officers. Then they are looking into how the same officers will also process the actual asylum claims. And then once somebody does not prevail with the US asylum office, then they will be referred to court instead of being referred to court after passing the credible fear interview, which will help to kind of reduce the backlogs we have in immigration courts. But again, also the asylum offices, they are backlogged. Like as we speak, we have cases. I do have a case or cases that have been pending since 2015, since 2016, 17, 18, 19. So we have also the asylum offices, they are backlogged. So I don't know if that's going to solve the problem. So we will see. Right. So now let me get to the other rather good news, which, and by the way, I wanted to also talk about the Ukrainian refugees as well. So the good news is the White House will resettle 100,000 Ukrainian refugees, and it's also reported that there are Ukrainians at the U.S.-Mexico border. About 1,000 have arrived at the U.S.-Mexico border this month, so which is a major increase from 2,072 encountered in February. And also some other Russian immigrants as well have been spotted at the southern border. So the U.S.-Mexico border, which is the southern border, is being busy. So it's being, like not only people coming from Latin America or Haiti and other countries, but Ukrainians, Russians. So they're all coming through the southern border, but also the Biden administration will issue 100,000 refugee status to Ukrainians. So, which, I mean, that's the least that they can do given the situation that we are in right now. So now, I say I was gonna talk about the new I don't even know. Yeah, I guess it's a rule. All these are rules. Okay. USCIS has, I told you guys that I didn't very much because, I didn't have time for that. So let me see. Two, three. Okay. Okay. All right. So USCIS has said, okay, they are now looking into efforts to increase efficiency. So, everybody who has an immigration case, who has a friend, a family member that has any type of case with immigration, it could be a citizenship application, it could be a simple change of status, it could be a complicated asylum case, it could be anything. It's be taking forever, forever. I'm not even joking. Employment authorization applications, they are taking a year, really. If I'm not like 8 to 10 to 12 months to be processed. So now USCIS says they are looking into ways to increase efficiency by streamlining certain different processes. So they're setting goals on how the processing times for certain cases. So now they are saying if you file an I-129 or I-140, which is employment-based, temporary or green card, they will premium process it within 2 months. If it's a regular process, the I-29 will take 2 months. Now the I-129, depending on which office you file, if you do not process if you do not process or premium process, it takes months and months, depending on which office. So now they're saying the I-129 will take 2 months regular processing. The employment EAD cards, they will take 3 months. However, the good news I said I was going to tell you was now USCIS is making available, is expanding the applications that can file for premium processing. And it is including the EAD. So if you have an employment authorization document application, either new application or renewal, if you have money, you can apply, you will be able to apply for premium processing. And the premium processing fee, so they will announce the fees, the premium processing fee, like what I'm reading, it, for the EAD will be less because usually the premium processing fee is $2,500. So the dollars, by the way. So the premium processing fee for the EAD application will be $1,500, $1,500. So some people will pay that because the way these processes are pending, the people are losing their jobs because if you don't have a card, if you all you have is your EAD, you can drive, like I was saying, if you cannot extend your driver's license, and your employer needs to see you are authorized to work in the US. So if you don't have an employment authorization document or your EAD has expired and the period of extension has expired, then if you can pay $1,500, which is $1,500, then you'll be able to do that. Some people have been asking, please expand the premium processing to the EAD to other applications so we can use this premium processing service. So that's good news. Also, it's only going to apply to the EAD. We also apply to certain change of status filed on Form I-539. So that's very good news. But regardless of whether you get you apply premium processing, now USCIS is setting goals they call new cycle time goals that by, I believe it's saying the new cycle goals will begin okay. All right, so that's for this month. They're saying they will process the I-765, which is the EAD application, within 3 months, the advanced parole within 3 months, the application to change status, I-539 application, change or extend status within 3 months, and the IA-24, which application to make changes on an approved petition or application within 3 months. Now, I need to tell you that, like, to put into perspective, we have pending EAD, meaning forms I-765, forms I-131 that have been pending for over 10 months, over a year. We have I-539, extension or change of status, even F1 reinstatement that have been pending for over a year. So now they are saying the new cycle goal will be 3 months. So the issue I have with this is, does that mean they will go back into these pending applications? Because what has been happening with this administration is now when they came in, they started as if, okay, the application they are receiving right now, they will processing faster. But what about the applications that have been pending for a year or 2 years? What's happening to them? Because yes, I have seen the EAD card or which employment authorization document applications, new applications that we filed like in July, October, being processed faster. But those that have been filed before this administration took office, they are still pending. So, and also those people, they did file their petitions, and they, so like they have, even if they're saying they're streamlining their processes, it's still so disorganized how this streamline process is going, because the people who filed a long time ago, they are still pending. Either asylum cases have been filed since 2016, their adjustment of status, EAD, like employment authorization, simple employment authorization, a document pending over a year. I'm not exaggerating. If you ask me for receipts, I will give you receipts. So it's good news for those who are applying right now, I guess, because they say this is this month, a new goal for this month of April. Is it March? So I don't know. Anyways, some other news on employment authorization documents is that they will extend validity periods, right? But the issue with extending the validity period, which is right now when you file a renewal of your I-765, which is the EAD, you are extended 180 days. So I don't know if now they're going to extend for a year. But also then the employers, they are not, some of them, they don't know, they're not taking unless you have a card with a picture on, they're not taking a paper which says, okay, your EAD is extended for another 6 months or a year. So I don't know if that's gonna help. For some, it's going to help, but other people, if you don't have a card, like if you don't have a driver's license and you tell me, I have a paper that says my expired driver's license is extended for 12 months, probably not gonna work, right? Maybe, I don't know, it works here sometimes, but some of the employers are not, they don't even wanna deal with that, okay? So, and also USCIS is committed to expedite renewal applications for healthcare and childcare workers. So let me summarize, because I've been, I've been going on for a while now. So basically what I came here to say is the good news I have really today is that the Title 42 is being eliminated, right? And which is a good news, Title 42 is being eliminated, and there's a new ways to process asylum claims from those who apply at the border, subject to expedite removal. They will be processed by USCIS, which will, I guess, clear the backlogs of immigration courts. I did mention my other issues with that because to me, it's just, if you just logged in right now, maybe go back and hear my comments on that. And also the good news, I guess the biggest news is that USCIS is going to streamline the processes of different applications. They are setting new cycle goals to process applications, the EADs, in 3 months, and they are setting a premium processing. They're expanding the premium processing program to the EAD, so that if you file from premium processing, you'll be able to obtain in 30 days. And they are also extending the premium processing to some other petitions such as I-539, and they're setting new rules and goals to make these backlogs, I guess, reduced, because has been ridiculous that every single application you file, doesn't matter how simple. By the way, for the citizenship, the goal is to process within 6 months. The even adjustment of status, and yeah, so we'll see that. We'll see. I mean, it's good. It's good they're making efforts, but my point was that sometimes they are solving one problem but creating 5 more problems. So, we take what we will take what we are given. We are grateful. So, please, if you like these videos, if you want to hear more, don't hesitate to share with your friends, to share with those who have a work permit pending, or to comment and subscribe. The whole thing. And thank you. So I'm gonna stop recording.